Thank you all for coming tonight. Really appreciate it. The purpose of this meeting is to talk about the proposed deal with the golf course that we've signed the letter of intent to. So we want to talk about the details of what it is that we've negotiated, as well as the next steps of how it's going to get approved and so forth. So I will go, we've got a presentation. What I'd like to do is go through the presentation. For those of you that have not seen it before, haven't looked on the web, we tried to anticipate a lot of the major questions, and so as we get into the end of it, you'll see a lot of things that a bunch of people have asked about. So if we can get through the presentation, then we'll open it up to questions for anything that anybody wants to ask about this proposed deal. What I'd like to do with the questions is do it the same way we kind of do with our meetings, and that is anybody who wants to can ask a question. What I would ask though is if you have multiple questions, ask one and then let everybody else have a chance, and then we'll keep going around until hopefully everybody's questions get answered. Okay, so if that's okay, then we'll get started. Here's what I want to talk about tonight. You know that we've been working on negotiating an agreement. We started pretty much, it's been a year now. We did get a letter of intent toward the end of last year. So what we want to do is talk about a little bit about the history and background that led us into these negotiations and kind of what we were trying to accomplish on them. We'll talk about, most of the presentation will be that second bullet point, exactly what's in the new agreement. Okay. Then we'll talk a little bit about what are the risks to the association, the next steps in summary, and then we'll take questions. I do want to emphasize one point up front, just so that everybody understands where we are in the process right now. Okay. We have gotten to the point where we've signed a letter of intent, which basically means that after many months talking with the golf course, the SOA and the golf course came to agreement on what we think are the main points of this deal. Okay. We also, at the very end, the last two meetings, in fact, and only the last two meetings, we brought the developer in because, as you'll see, he has a role to play because he has some lingering rights with regard to the golf course and association. So we had to bring him in. And so where we are now is we've agreed in principle on all the key points. What happens next, and what we're in the process of doing right now, is we actually have to draw up the actual agreement, which would be the contract, if you want to think of it that way. So that is not signed yet, which means the letter of intent and the way we're proceeding, and I know from talking with the president of the golf course over there, they're looking at it the same way. We think we have an agreement. As you've probably all heard, ultimately, you will all get to vote on it. And that's what will either approve or not approve the agreement. But before we get to the vote, we have to actually have the signed agreement, which would be the legal contract, if you will. So that's what's being worked on right now. What I'm going to cover is what we want to put in the contract agreement and what we and the golf course and the developer have agreed to date, but it's not a done deal yet. So I just want everybody to understand that. And we'll talk a little bit later on about the timing of hopefully how to get it to be a done deal. Okay, this map is a little bit hard to see, I know, but it's just to give you perspective. The yellow outline is the Somerset boundary. That includes all of Somerset, this is Sierra Canyon, down in here, the main entrance through the rock fall where we had all the problems is up here. The point of this slide, though, is if you look at the red area, that is the land that's owned by the golf course. Okay, that is not part of Somerset, which we'll talk a little bit more about is part of the issue, in our perspective anyway. But that is all of the land, anything you see in red is what's owned by the golf course right now. So the point of this is to just basically give the perspective. In our case, the golf course is not something that's over in the corner that affects a few houses around it. It is all through the community. Okay, just some quick background. I'll go through this. As I just said, the golf club is separate from the association. They, in fact, are not bound by any of our rules or any of our requirements. They don't have to come to us for architectural approval or anything else. Okay, they're a totally separate entity. Back toward the end of 2010, the developer who built Somerset and set up the country club originally turned over the golf course to the equity members. Okay, and then, as I'm sure everybody's aware, about a year later, the developer controlled board and the country club entered into a amenity access agreement, which is we're still working under right now. And that was basically the golf course would provide access to Somerset members for certain amenities like using the restaurant or stuff like that. And in return, they got paid for that on a monthly basis. That was done by the developer control board, and as I'm sure a lot of you in here are aware, or maybe have been involved in some of the meetings, that's caused a lot of, say, discussion within the community. Okay, what is that amenities contract that we have in place right now? Here's kind of a summary of it. What's it do? It allows any Somerset member, when I say Somerset member here, I'm talking about obviously Somerset members who aren't already golf club members, because most of their members are in fact Somerset homeowners, but this was intended to apply to people who lived in Somerset but did not join the country club. So they can play 2 rounds a year at certain prices depending on exactly when they're going to play. They opened up the use of the driving range, but only from the back end of the range where they opened up, put a little synthetic strip. And then we had to pay either $3 or $5 for a bag of balls, depending on whether you wanted a big bag or a little bag. We're eligible to attend golf lessons or clinics. We can use the bocce ball courts that they built. We had access to the restaurant, access to the pro shop, and they set up some catch and release fishing in the pond that's down behind the clubhouse. It's on at the hole 9 of Canyon 9. And this is the stuff that we can use right now. Okay. So you've probably, seen that stuff before, heard about it. Okay. The key thing here is, though, what does that cost us? Okay. And as, again, you may know, basically the agreement was the association would pay $15 per unit per month for every activated unit. So every unit that's paying an assessment, $15 of that assessment goes toward paying for access to those amenities. Now, the contract was set up, it was originally set up as a 10-year contract, but it has some options. So the way the contract's set up is that after the first 3 years, there was an option where you could either extend the contract or cut it off at that point. If you extended it, you can extend it for another 3 years and the price drops to $12 per unit. And if you get to the end of those 3 years, you can extend it for another 4 years. So it's a total of 10 years. And the reason I bring that up is that's the difference between the two numbers I have up here. The 3 years ends at the end of 2014 for the first 3-year period. Okay? If we kept the contract through that period, we would pay roughly $1.3 million. If it extended through the full 10 years, we would pay roughly $4.2 million. And I say roughly because the number of units changes. These numbers use the numbers that we have used for our budgeting purposes to project how fast houses are going to be built or whatever. But it's in those ballparks. And the key thing here is at the end of whether it was 3 years or 5 years, we spent that money, what did we get? What would the association be left with? And the answer to that is nothing. The lease is over. They called it a lease. I dispute that. But the amenity access is over. Everybody walks away. We've paid a bunch of money, and that's the end of that. Unless we wanted to, or unless they wanted to let us extend it some more. So that's kind of where, what this amenity agreement that everybody talks about is about. And that kind of brings us, say, to the beginning of last year, which was kind of a milestone in that the developer, January 1st, 2013, the developer stepped out of the Homeowners Association. We had our first all-homeowner board, which is what's in place right now. We've just recently had our second homeowner election. So basically, oops, just postpone.
Change to remind me, Tony.
Yeah, I'll put that down to never. Okay, so basically what happened this year is we had the homeowners took over for the first time. So the developer is no longer involved on the board or has any kind of official role in the association. Within 2 weeks of that happening, we had our first contacts with the golf course to say, you know what, let's see, can we make this a better deal in some way? We started talking with them, and then around May, we got a letter from the Nevada Real Estate Department, Division, whatever it's called. Basically, as was well known, if anybody came to board meetings and stuff, we had a resident who filed a complaint with the Ombudsman's office about this amenity agreement. And back on May 31st is when we got the response that said basically from the Ombudsman office, we think there may be enough here, we think it should go to a hearing. The way that works in Nevada, the Ombudsman's office doesn't determine, whether there's been a violation, but what they'll do is if they think there's grounds. Okay, we're hitting all of it tonight. Okay, if they, thank you, Byron. Just if that kind of stuff happens again, boy, because I'm not looking back there all that much. So, so basically, what happens is the Ombudsman's office, if they say, well, we think something may have happened, because what they do is somebody files a complaint, they'll give the Ombudsman's office whatever evidence or explanation they think justifies it. Usually, I think always, I assume, we get a letter that says somebody's filed a complaint. Please provide us with information on this topic. They'll look at that, and in this case, they said, well, we think there might be something there. Okay. What they do, if they do think there's something there, they can't make that judgment. They basically ask for a hearing, which is there's a panel of 5 commissioners in Nevada, and that's what they do, is they go all around the state listening to homeowner association hearings. So the department asked for a hearing. What that does, because the department is part of the state government, any legal action they're involved in is handled by the Attorney General's office, because the Attorney General is the attorney for the state of Nevada. Okay? So what happened is we had a meeting with them back on, it was like right at the beginning of July. It may have been like July 2nd or 5th or somewhere right in there. We met with them, and interestingly enough, let me make one thing clear. What the Ombudsman's office sent us wasn't sent really to this board, it was sent to the previous board. I mean, we get it because obviously we're involved in it, but the issue that was alleged was that the previous board didn't really have the right to get into this contract that we just talked about, the amenity contract. And so they and the developer were called for this hearing, and then we were called to come in because obviously it affects us. We're now the association. So after talking with them at the meeting, what the Attorney General's office and the Department of Real Estate decided to do was suspend the investigation, because we told them we had already started negotiating, that we were looking to improve the deal. And they said, okay, we'll give you some time to do that. And they suspended the investigation with the understanding that we would make our best effort to actually come up with a new agreement. And we had told them that our plan was if we come up with a new agreement, we're going to put it to a homeowner vote. So that's what happened there. Now, oops, what did I just do? Okay. Now, so this gets us down to around July, and so as I said, we had started talking with the golf course back in like January, and so we're learning more and where things are going on. And in the background of all this day-to-day stuff, which I'll call this, a couple of other things came up that really struck, when I say us, it'll be the negotiating team. That was, the board assigned this to myself and Danielle Kirby, who has been at all these meetings before. She had a death in the family over the holidays, so she's out of town right now. And then we brought in Ray Lee, because of his financial expertise and because he was involved in some of the original discussions that led to that amenity access agreement, and we needed to have that kind of knowledge to help us navigate this. So what we became aware of as we were talking about this stuff were a couple things that became clear to us, at least in our opinion, are pretty major problems facing the association in Somerset as a community in terms of strategic long-term risks. First one is, these are not in any particular order, but we have water rights. The association owns its own water rights to Water Canyon 9. Those water rights are exclusively from the Truckee River. Now there's a bunch of pipes and a pump house and pumps at both ends and all kinds of stuff to get that water up here. We don't own any of that stuff. The golf course owns it. Okay? That, you can see, if something happens at the golf course, that could be a big problem for us with even our own little short course. In fact, if you look at the pond that's out behind the Club at Town Center, which is on hole 9, I think, of the Canyon 9, that pond is where all the water is drawn from to irrigate the Canyon 9 golf course. That's the reservoir, and there are pipes and pumps and stuff that pull water out of that. We don't own that pond, even though it's on the Canyon 9. The golf course owns the pond. Now you can ask, well, why is that? That seems kind of flaky, and I would agree with you. But the fact is, when the developer built this place, and for some pretty reasonable reasons, I think, there's a pipe that runs literally from the Truckee River up around Mogul, up through the canyon where the canyon path is, and finally to the pond. That brings the water to Canyon 9. It also brings water that's used to water the big golf course. There's no way it made sense to build 2 of those kinds of infrastructures. They probably couldn't get the permits for it. Now, why did the developer put the ownership of that into the golf club rather than into the SOA? I have no idea. But that's what happened. So we don't own that infrastructure at all. We do not own the pond that's behind there, that's the source, the reservoir for all the irrigation water. We don't own the pump house, the little dam, any of that stuff that's there. We don't own any of that. Then the other thing is, as you saw that picture I showed earlier, and as I said, their land kind of is spread out all over the place, but we have absolutely nothing to say about what happens on that. It's private property. It's not within our governing authority. It's not subject to any of our rules or regulations. And in fact, one of the things that the developer did when he turned it over to the golf course was he put reverter rights on it, which basically say if it stops operating as a golf course for a certain period of time, the land and the water rights and all that stuff goes back to the developer. And then the developer's clearly free to do whatever he wants. He could come in, he could build houses on it, he could sell it to another builder, he could move the water and just let it go brown and take the water to some other development if he wanted to. There's all kinds of things that could happen, and we don't have anything to say about that. And, I think most people will agree to me that the fact that that land's there and it's green, it's a golf course, it matches in with all our nice landscaping through Somerset, it does affect homeowner values. Okay, so, but it was kind of scary to realize just how much of this stuff we had nothing to say about. So, what's happened since then? So sort of since July-ish. Okay, well, we continued talking with the golf course. We looked at lots of different options, and we'll talk about that a little bit tonight, and you'll probably have some questions. And I know from some of the other meetings, the answers sometimes are, yeah, well, we did look at that. For whatever reason, we couldn't get it, or it didn't make sense to us after we considered it, whatever. But we can go through all that. And we finally got to the point toward, I'll tell you exactly when it was, November 14th. We got to the point where we signed a letter of intent saying that after looking at all these things, we think we've come up with a deal that both sides can benefit from. I want to point out, as I said before, though, that this is only the case if the homeowners, and in fact, if the equity members of the golf course vote to approve it. So we're not a done deal. It still has a ways to go. If it is approved and put into place, one of the things that will trigger is that existing amenity agreement that's in place stops, cancels, it's done. Okay. So, I want to talk about now what's in the agreement. And the first thing I want to say is, well, how did we on the SOA side go about trying to negotiate this agreement? And in doing that, we basically established for ourselves three key principles that drove the way we came at these discussions. One was that any kind of an agreement that we come up with has to help address those strategic risks that I was talking about. The fact that we don't own our own pipes, that kind of stuff. That we don't have anything to say about what happens on golf course land, especially if the golf course goes away. And that was the key thing, that the more we got into it, the more we realized that our objective had to be to try to protect the Somerset community regardless of what happens to the golf course. We have no idea, and you know, I don't think anybody has a crystal ball to say, is the golf course going to succeed, and will they be here, you know, 3 years, 5 years, 10 years, 50 years from now, or will they fail? And if they fail, when will they fail? We have no idea. So we started looking at this, when I say we, again, Danielle and myself and Ray started looking at this as, we need to protect Somerset no matter what happens. And that introduced a pretty interesting twist in this. And the last one was, whatever deal we come up with, we had to believe it was a fair deal for the homeowners. It presented fair value for anything that we got or agreed to. If we were going to pay for something, that overall it had to have, you know, fair value. And we actually put these on the table reasonably early on with the golf course. And we just said, hey, if it's not going to meet those, that's the end of the discussion. So, what are the key points of the agreement? Well, there's a bunch of them in there, and we're going to go through a few of them in detail, and then I'll give you some of the other highlights, and we'll talk about that. But basically, what we've agreed is that the SOA will purchase the real property that's owned by the golf course. Okay. What's that include? Well, there's about 400, it's actually a little bit more than 400 acre-feet of water rights, plus an additional 100 acre-feet of supplemental water rights. So we will be the owners of those water rights. We will own the water pumping stations and all the related facilities, both from the Truckee River up to Somerset and all through Somerset as well, because they're all kind of interconnected and designed that way. We will get approximately 220 acres of green space. And the reason I say green space is it may be a golf course or it may not be a golf course at some point in time. But because we will own the water, it will always stay green, which was one of the issues that's come up. As part of this, though, we did say that the country club can retain about 6 acres, which is right where their current parking lot and the restaurant and stuff like that. And we'll talk about why we did that a little bit more. In addition to, so let me just emphasize, the 220 acres is basically, if you want to think of it this way, all the land that's under the golf course itself. And I say it that way specifically because we, in putting together this deal from our side, we don't look at this as buying a golf course. We're not trying to get into the golf course business. We'll talk about that a little bit more too. But we do want to own the land underneath for a variety of reasons. In addition, we'll get the maintenance building and all the surrounding grounds of that, as well as the driving range that's over there. And here's, in my mind, probably the most important thing of this. We will get the reverter rights from the developer. Those will come over to the SOA. So that means the bottom line of all this is 2 things, I'd say. One is Somerset will never go through what Northgate did or what DeAndrea did, because even if it's not a golf course, it will be green, and it will be used by the association. And that's the other key thing. Somerset Association, future homeowners, future boards, will be able to control whatever happens inside this community. Whereas right now, we can have all kinds of things happen that we have nothing to say about. Okay. These are really the key things. I just emphasize. We'll own the water, we'll own the infrastructure, we'll own the land, and we get the reverter rights, which means there's really nothing left that people outside of Somerset have exclusive control of, except for that little 6 acres. We'll talk about that. But what else is in the agreement? There's a whole bunch of other stuff in there. I put this slide up just to show you what about the amenities that we were paying $15 a month for per unit right now. Well, what happens there? If you look at the left side of this slide, this is basically the same slide I put up earlier. This side says what happens if this deal is approved by the homeowners. Okay, first of all, we will, not just to the end of the agreement or whatever, but as long as the country club's there, we will have access to all those amenities, and we don't pay anything else. At this point, all the payments, there will be no monthly payments or anything like that. Instead of 2 rounds of golf, you can get 4 rounds of golf. They do have a rule. It turns out the country club has a rule with its own members that they can only bring the same guest in. Like right now, the rule is no more than 4 times. Well, we'll follow that same rule. So, an individual, like I can't go around, collect all the coupons or whatever from all my neighbors who don't golf, and I don't golf either, but just for the sake of discussion, go over there and say, oh, look, I can play 50 rounds of golf. If you allow people to do that, then they're going to fail as a country club. Why would anybody join? Okay? Now, the driving range, which is an interesting thing because from what I've heard since I've become president of the association, it's kind of a really love-hate thing. It is probably the best add-on amenity in terms of when you talk to people what they're really passionate about, they're like, yeah, that driving range is great. But it's also the most hated one because you have to go to the back, you got to wait for the shuttle. People feel like, well, what are we, second-class citizens or something like that. So we've gotten more complaints as well as more compliments about the driving range, at least I have, than probably anything else. So what did we do with that? First of all, you can still shoot from the back, except now it's free and you can hit as many balls as you want. Okay, you can stay out there all day if you want to do that. If you want to hit from the front, from the grass area, we now will have the right to do that, but it's unlimited number of balls all day if you want, but it will be a $10 fee. And the reason for that is that driving range takes a whole lot of abuse. And, I mean, if you go out there anyway, you'll see that they've set up, okay, you tee off here, the next day that moves up a few feet, and that's to allow the grass to recover. And, you know, if they basically made an argument that sounded pretty reasonable, that if suddenly you double or triple the use of the driving range and people can stay out there for 6 hours, you're going to beat up that driving range to the point where it's not going to be very good for anybody. So there will be a fee, but again, if you want to do that, if you want to hit off the grass, you can hit as many balls as you want. You can stay out there all day. Bocce ball will continue to be free. Interesting thing here, just for a point. That now is the second most used amenity in this whole package. The only one that's used more is the restaurant, which kind of surprised me when I saw that, but that one has really taken off. We'll still have access to the restaurant pro shop. Basically, none of that changes. So that's what's part of the new agreement with regard to the amenities. Question a lot of you are asking is, what's the price of all this? Okay, what are we doing? $2.75 million. And I'll let you think about that for a minute, but I want to come back and put it in context. A key thing, and we did this the way we negotiated this, once we make that payment, the association has absolutely no further financial obligation to support the country club or make payments or stuff like that. Okay. Why did we do it this way? Well, not jump ahead. I tend to jump ahead of myself before I even look at what I have. The real question, I guess, is this a fair price? Okay, is that a good deal for the homeowners for what we're getting? Here's some recent benchmarks. You may have noticed, just like December 30th or 28th or somewhere right in there was an article in the Reno Gazette-Journal, Lake Ridge, which had been in bankruptcy, just sold. It sold for $5.5 million. It does have water, which we also will have. That's actually only about a 155-acre golf course. Ours is like 220 plus. So, but that's the most recent one. And there's a couple things around here that I think really make this particularly interesting for us. First of all, they do have water rights, but they, as I understand, they get their water exclusively from the lake ditch, which means they've got to pay, it's Truckee River water, but it's delivered to them through the lake ditch, which means they've got to pay the ditch operator something for getting the water to them. We don't have to pay anybody anything for getting water to us once we own the infrastructure. The other thing is because all of their water, at least what I've learned so far, this just happened, so I'm trying to find out, make sure I have all, but what I've been told so far, because it's all Truckee River water, our water is a combination of Truckee River, or the water permits we would be buying, Truckee River groundwater and spring water. We actually have a lot more flexibility in operating the water and how we use it than they do. But that's the most recent one. You had Northgate, which was sold in 2011, near and dear to the hearts of many people in Somerset. That sold for $2.4 million without any water rights. And that's why it still looks like it does now, because if you don't have water rights for a golf course, it becomes prohibitively expensive to buy water in order to water it. Now, I put the 2.4 number on there. That was a number that was in the paper. I've been told by a couple people and seen a couple things that it may have been closer to 2.7, but I don't really know what those discrepancies are, so I just stuck to 2.4. We have another thing. Now, this is older. This was 2005, but to give you an idea, Washoe County sold 174 acre-feet of water from Sierra Sage Golf Course for approximately, for better than, they got $7 million for 174 acre-feet, which is better than $40,000 an acre. Now, we're getting 400 and some acre-feet included in the 2.75 million. Okay, now, and recognize, I mean, the fair thing to say here is the price of water changes, just like the price of a lot of things change over time. When there's high demand, it's more expensive. When there's low demand, it's less expensive. So that is a dated number. I mean, I know from stuff I've looked at, the developer paid as much as $50,000 an acre foot of water for some of the water that he bought from Somerset. Now, I tried to get, and I asked our water consultant, what's a reasonable average number to talk about this stuff? Because each water permit's different depending on the age, the source, the designated use. You know, there's a lot of things that affect it. But he said a good overall number to use right now in terms of the value of water is, the value of water in our area is about $6,000 per acre foot on average. Okay, so if you take the 400 acre feet we would get at 6,000, that right there is 2.4 million, not including paying anything for the supplemental water rights. So I'm just trying to put that in context. And the water prices do change. I was talking with our water surveyor last week, and he just sold 4 acre feet for $20,000 an acre foot down in the Reno area. So, on top of that, we get the permanent control. What's that worth? It's significant. We have some estimates, but it's pretty judgmental how to do that. And, you know, do you want to throw in anything extra for the perpetual access to the amenities? You can decide. But hopefully you can see that that's, you know, the value here is pretty significant in excess of the 2.75 million. Okay. Here's another thing to keep in mind on this. Oops, wait a minute. Okay. Here. Another way to put it in context is from the numbers we have in place with the current agreement, we're paying, or will have paid, about $420,000 a year for amenity access. Okay, what's it going to cost us to take out a loan to pay the $2.75 million? Well, we contacted some banks to get some rough ideas. Right now, interest rates for these kinds of loans would be about 5%. If we amortize 20 years, we're paying $220 a year rather than $420. If we amortize 10 years, it goes up to $350. It's still a lot less than what we're paying right now without ending up owning anything. If rates increase, it turns out a 1% increase in interest rates will cost you about 67 cents per unit per month additional. Okay, so it's very manageable. The key thing is, one of the things we tried to make sure is we wouldn't have to increase assessments at all because of this deal. So right now, our assessments include $15 a month that goes to the golf course. We can service the loan for a lot less than $15 a month per unit. Okay. What would it cost? Well, based on the number of units you assume over the lifetime of that, and depending on how long we amortize it, we estimate between $740 and $1177 a month. That's based on the current number of units. As that builds out, we think that'll drop. There's some numbers there. All these numbers are less than $15 a month. So what happens to the $15? Well, what we will propose, what the board will propose happens, is that the excess, or whatever's left over, we use it to put in reserves. Because we're going to have to start reserving for the pumps and the pipes and all that kind of good stuff. Okay. Once we build up the reserves adequately, that's an opportunity to either use it for something else or reduce assessments or whatever. The other thing that we've negotiated in this deal, which is really critical, particularly when you think about the cost and setting up reserves, is how do we know we're not going to get something where suddenly we got to do a lot of repairs? And that's particularly true with things like wells and pipes and stuff like that. Well, we've got we will have, if this is approved, for the first 4 years, we'll have a full warranty. The golf course is responsible for anything that happens that needs to be fixed. So that gives us even more breathing room to use our money to build reserves, or once we get comfortable at the reserve level, we can use it for other things without worrying, are we taking a huge risk because they didn't tell us that something's happening to the well and there's no way to find that out until it happens or something, I don't know. But we got a warranty for everything in there. So again, the main point of all this is we can do this deal and get substantial value without raising assessments and with the potential to even lower assessments because of this deal once we're all comfortable with the reserve levels. Okay. There is a question that keeps coming up on this, and that is, why do we want to borrow the money and stretch it out? That was actually a very conscious decision. And the reasoning is this, okay? If the SOA ends up owning the land and the water rights and stuff like that, that's going to provide substantial value to everybody who lives here for a long time. In essence, for as long as there's a Somerset, which is probably forever, okay? If we just paid right up front right now, that means us, who are homeowners right now, pay the full cost, even though the benefits go out to people who haven't even moved here yet, or to the people who will move into the houses where houses haven't been built that are under construction or will be built in the future. We specifically decided that it made sense to try to do this with taking out a loan as a way to spread the cost to include the people who will get the future benefits. So that was the reasoning behind saying we'd rather borrow the money than try to figure out if there's a way we can get it out of other accounts or things like that. Okay, why are they keeping 6 acres? Well, the whole point of this deal, as I understand it from their point of view, is to get a one-shot injection that will help them build, with all their other financing stuff, will help them build a clubhouse. Because they believe that's the key to attracting more equity members, is being able to offer a year-round type amenity, which is pretty hard for them to do without a clubhouse. Well, we talked about whether we would own the land or they would own the land or different ways that could work, but the bottom line is this. We, the SOA representatives, decided that we would rather just have a clean break. We make the payment, we get the stuff that we get, they're on their own. If we own the land, there's always going to be, at least in appearance, if not in actuality, who's responsible for this? Are we really supporting them? Are we, if we do, like one of the deals we talked about was maybe build a bigger building that could be their clubhouse plus a room for us, then there's always going to be, are we in bed together? By giving them the land, leaving it totally out of our control, in terms of we don't have any financial obligation, that's the reason for that. Plus, keep in mind for every one of these provisions, this was a negotiated agreement. Neither party could dictate to the other party exactly what they wanted. So this is what we negotiated, but from our point of view, we thought this was the best way to make sure the SOA has a clean cut and does not have any further obligation, because even if we said they had to do something, if we're the property owner, that could be, you never know what comes up with the building or whatever. We didn't want to have anything to do with it. We also have some protections in this agreement if the golf course ever tries to sell that parcel. First of all, if we already own the land under the golf course and the water and everything else, we think there's probably going to be relatively few people that are interested in just that piece of land up by the parking lot, and it clearly limits what people could do compared to if they owned all that land. So I think that protects us in a way. But we did negotiate two rights of first refusal. One is we will always have a right of first refusal. If they try to sell it, we can meet that price and we can buy it. And that's something that homeowners can decide at the time. However, we also specifically negotiated that if they try to sell it within the first 5 years, we can buy it at 50% of their best offer. Okay. Why did we do that? Because, and we told them this flat out, we don't want them to look for a way to make money, pick up, and take off. We want them to make their best effort to actually be successful according to their business model. And we figured that 5 years would, we would know. Either they're going to be successful or not, but it's going to be pretty clear. And if they try to get out early without making that best effort, great, we'll just buy it for half price. Okay. Now, given that we will own the land under the golf course, what happens to all that? And what obligations do we have toward watering it or maintaining it or anything else? Okay. The answer is we're going to lease it back to them. Okay. And we're going to lease it back to them at a really cheap rate, $1,000 a year plus $1,200 a year as a reserve contribution with escalation, for inflation. So for $2,200 a year. However, they will only be allowed to operate a private member-owned golf club. That's their business model, and we're going to hold them to that. Okay. The lease term will be 50 years with 2 20-year extensions, and they do not have the right to sell it, assign it, or transfer it in any way to anybody else. So basically what this says is if they can be a successful golf club, they can stay there for a long time, and we get the benefit of having a golf community if you happen to be a golfer, or we get the benefit of it staying nice and green and pretty and attracting other people, even if you're not a golfer, like I'm not a golfer, so. But the key to this too, because a lot of people say, well, why do we do that so cheap? Okay, and I got a slide on that later. I won't jump right on. Okay, what else is in the proposal? Well, right now, they in fact operate and do all the maintenance on the water system, including the Canyon 9. Okay, so we're going to have them continue to operate at no cost to us. We're not going to be paying that as a service fee or anything. But that means we don't have to hire somebody to do that. However, we do have requirements. We have things in there. And when I keep saying we have things in there and stuff, I urge everybody, read the letter of intent. It's got the details that I'm summarizing, and it's on the website. So you can see that if you want. They do have to keep us updated with information on system status and maintenance needs and what it has, even though they've got to do all that stuff, but they've got to keep us informed, and they have to train SOA staff that we designate, so in case we do take it over at some point, we know how to operate everything. The other thing, another provision is, if they fail to operate as a golf course, in 45 days, we can terminate the lease. Okay, the current reverter that the developer has on that is, I think, a year. It has to not operate for a year. Why is that so short? The reason that's so short is 45 days is plenty of time to ruin a golf course if nobody's maintaining it. So we want to keep that option open, which means they've got to really perform on what they said they were going to do. What are some of the other things that are in there? They will be responsible for all of the maintenance that goes on and operating costs of the golf course. So basically, everything that's in the boundaries of what we lease back to them, they are responsible for. So even though we are the owner, we don't have to come in and fix the bridge over the pond where the cart path broke or something like that. It's all their responsibility. If they don't make repairs, we have the right to go in there, make repairs, and charge it back. I mean, this is kind of the reason for the short time periods and for provisions like this is, as you all know, most of the time, or many times, it's a lot easier and cheaper to fix something if you fix it when you first know it needs it than to let it go all to pieces and then have to come in and fix it. So that's the reason for these provisions. They're responsible for all these costs, though. They're responsible for basically all their business costs. If you want to think of it this way, kind of the general principle was they have to keep paying all the costs they have to pay right now. And that's one of the reasons for the low lease costs. Okay, we as landlords are not going to take on responsibility for fixing the golf course or stuff like that. There's one issue that's yet to be resolved, and not because of disagreement between us and them, but we won't know the answer until we actually file the transfer papers. And that is the SOA as an entity. We don't pay property tax because of the kind of entity we are. We have agreed we'll use our best efforts to make sure when this land is transferred into our name that we can get it on a basis that doesn't pay property tax. But ultimately, that's up to the Washoe County assessor. Okay? And what we've got in this letter of agreement is we'll make our best efforts to make sure that we don't have to pay property tax, but if in fact we do, we're going to add it back to the lease price. Okay. Here's the question. Why didn't we get higher payments from them? Okay. And the answer is, I mean, there's a lot of parts to this answer. One is that we couldn't unilaterally impose them. We actually did talk with the golf course about higher payments. We talked about a number of different price levels, but the bottom line was to get them to accept those, we'd have to pay more upfront or take on ongoing financial responsibilities for maintenance or there were various kind of options that we looked at. The bottom line is we decided that it's in the SOA's best interest to go with a lower lease cost and get away from any other future costs. Okay, and the reason, or pay more for it up front. Okay, and we're not doing this, as I said earlier, we're not doing this to get into the golf course business. We're doing this to protect the community and especially to keep the property from reverting back to the developer, which would potentially could cause a lot of problems. Okay, we also looked at what would it cost to maintain the golf course if the SOA took it on. One of the options that we did investigate with golf clubs was, why don't we just buy it outright, make it a Somerset golf course, forget about the clubhouse, let everybody play? Well, the answer is, back of the envelope calculation, it would probably require a $50 to $70 increase above your current assessment rates right now. So that's over and above the $15 that's already in there. Okay, and that's just based on looking at what the cost is to keep the course in the condition it is right now. To come up with that number, what we basically did is looked at some of their operating costs in the past, backed out the restaurant, because it's not clear we want to keep the restaurants. We took all that cost out. It would still cost $50 to $70 per unit per month increase in assessments. Now, what's the spread there? Well, I mean, you can play games with this. The $70 number is pretty much, if we just wanted to pay for it as an association amenity, pay for it out of assessments, okay? Do we charge people to golf? Yeah, probably. So you can make some scenarios with how many people would golf from the community, what are the greens fees, do we want to allow a certain amount of public play? You can do that kind of stuff, but the fact is, if you assume you're going to get so much money from greens fees or carts fees or public play, and you don't, it's going to have to come out of assessments anyway. If we're owning it and we have to pay for it, if the projections don't work, it has to come out of assessments, which means if we don't build it into the price and go toward the 70, it means it probably have to do a special assessment. We don't want to do that. We don't want to run a golf course at all. Truth is. So that's what was driving us behind the idea of leasing it back to them and leasing it back cheaply. Because as you saw from the other slides, they have responsibility to pay for all the maintenance. So we're not making money off the golf course right now. We're not going to miss $1,000 a month or something. And we don't want to get into being a for-profit business trying to run this kind of stuff. But one of the benefits of doing it this way is they pay all the maintenance costs. And that means even the day-to-day landscaping, cutting the grass, all that kind of stuff, which means we don't have to pay for it. So we thought that was a better trade-off than getting $10,000 a month, $5,000 a month, and having to pay maybe $4 or $5 million, or having to do maintenance, having to have you guys pay for the maintenance costs. We thought this was a much cleaner way, keep the cost down as low as we can, and go on. So that's the reason of why we didn't get more, those two reasons. What happens if the golf course fails? Okay, this was a big part of our thinking, because it is about, as I said earlier, we had to be prepared no matter what happens at the golf course to protect the community. Well, the answer is we already own everything, so it all comes back to us without any hassle. And this is really important because we thought about what are the other options. And some of you may know that in the current amenity agreement, I think it's in the amenity agreement, that, there's a thing in there that says we can buy the golf course for $1 before they declare bankruptcy, stuff like that. The truth is, our being able to do that would likely never work, because it depends on them telling us when they're going to declare bankruptcy. And most bankruptcy judges do have the right to claw back things that happen just before bankruptcy if they see it as an attempt, to kind of get rid of stuff. The truth is, if they go into bankruptcy, a bankruptcy judge pretty much can do anything, which includes selling that land to the highest bidder for any use, stuff like that. We need to avoid the court fights. The other thing is, as I said, right now, the pipelines from the Truckee River and all that, the pond and all that, we don't own it. If they, whether it's in bankruptcy or if they just fold up, okay, we don't have the right to use that stuff. That's private property. We can't go on there and turn on the pumps or any of that kind of stuff. By the time we go to court to get some injunction or whatever we would need to get, chances are Canyon 9 would already be dead. I mean, especially if this happened in the middle of the summer. If it happens in the middle of the winter, we have a little bit more leeway. But by the fact that we would already own all the water and stuff, it comes back to us, and there's no question of somebody else buying it or a judge selling it off to people or whatever. I think I've covered the second point. The thing is what we're thinking too, is if the property reverts back to the association, if the golf course country club folds up for whatever reason, then we have a choice of what to do. And I would anticipate that whoever's the board at the time, would obviously be an important decision, and we should put it to a vote of the homeowners, and we'll have the choice of saying, do we want to keep it as a golf course? And are we willing to pay whatever that means, or how would we do that? Or do we want to just keep it as green space? Maybe we make it into a park, maybe we use it for some other amenities, to locate some other amenity, whatever. But the choice would be ours, and that's really what we're after with this whole thing. So, I'm getting right to the end here, so thank you for bearing with me. There's a bunch of other stuff in the letter of intent. What I've tried to cover, or what I think are really the key points. You can read the letter of intent. Like I said, it's on the website. We are in the process of trying to draft the new agreement, which will fill out all the details. And by the way, when we get to the point of homeowner vote, we will not have the vote before the final agreement is signed, which means you will get to see the actual agreement. You don't have to vote based on, what I've said here tonight, though we don't expect any of the major points that we've covered here to change. But you'll get to see that. Okay. What are the risks to the association? Well, there's the bank financing, our ability to finance it, based on some just preliminary fact-finding. That does not appear like it'll be a problem. Banks love to loan to homeowners associations. And by the way, it's not a mortgage in the sense the property does not get put up for collateral. It cannot be taken away if it's foreclosed. What banks loan to associations on is the financial health and the revenue stream from the assessments. And so since we can pay for pretty much any loan that's out there right now for less than what we're paying the country club, we should be able to do this without raising assessments at all. We've got, there's not much that can go wrong with grass and golf course stuff, but the biggest risk for the facilities are probably the water facilities because, one of the wells is 1,600 feet deep. It's pretty hard to, go down and see what's going on with that. And most of the time with the electric motors, which is all it is, submersible pump, it either works or it doesn't. It doesn't give you a lot of warning in a lot of cases. So there's some risk there, but we think we minimize that by getting a 4-year full coverage warranty. So there is a risk that this agreement will not get signed. The letter of intent says that this is what everybody's doing in good faith, but it's not binding legally until we get to the actual contract. So there's a chance that one side or the other, or the developer for that matter, will change their mind. Okay, we've talked about this a lot with all the parties, and everybody seems to be going into it with the idea that no, as long as those are the points that are reflected in the contract. Everybody's good with that. And then the final risks are either the homeowners, yourselves, if you're not members of the golf course, won't vote to approve it, or the golf club members, equity members, won't vote to approve it. So those are the things that could knock this off the rails. So what happens next? Well, this is the third one we've scheduled. We're going to have more of these meetings because we really believe the best thing that could happen for this deal is if everybody understands it and then votes according to what they think, as opposed to, voting based on rumors and things like that. So, we've already done, this is the third presentation. We'll schedule some more, and those will be, emailed out to people on when it's going to be. We have started our due diligence process. We have 90 days, basically. And these two bullet points are, the second and third one are going on simultaneously right now. We've started doing the due diligence, and we've started drafting the agreement. So we're working on that. We kind of expect, given the time periods here, we're targeting that the homeowner vote will start around the beginning of April. Give or take a little bit, depends on finishing the due diligence and finishing the contract, but we think that should be plenty of time, and we'll probably, allow maybe, 30, 60 days, something like that. So basically, by the time we get to the end of June, we should know the answer on this. And it all depends on having everybody, as many people as possible, voting. And whether you think it's a good deal or a bad deal, that's what's going to determine whether we do this deal. Regardless of whether the agreement's already signed, by the way, that question came up a couple times. But no, the agreement has in it a provision that specifically acknowledges it's not finished until the homeowners and the equity club members vote. So, what's the summary here? Well, we really think this is a win-win for both sides, quite frankly. For the golf course, it gives them, with the $2.75 million, it probably gives them the best shot to get to the point where they have a clubhouse and try to implement all of their plans, their business model, to see if they can really make it work. Okay? From our point of view, it eliminates all the strategic risks, no matter what happens to the golf course. So, the future of the golf course kind of goes out of this from the point of view of protecting the Somerset community and the property values here. Or worrying about whether we're going to have this big, brown area all through the community that's going to catch fire, and who knows what can happen out here. So we will get control pretty much of Somerset. For almost all the property within Somerset. The bottom line here, from my perspective, is I think this is a very unique opportunity, and if we don't do this now, I'm not sure we'll get the chance, especially with regard to developer reverter rights. That is a really critical part of this agreement, and we brought that in specifically because it has nothing to do with the golf course. Without the reverter rights, Somerset will always be at risk. So now it's up to you. Like I said, we'll have the vote. It's a very complex deal. We really want everybody to learn about it, to read the documents, to think about it, ask any questions. Over the holidays, I was not very focused on this, I'll admit, but I just posted some more answers to questions that have come in. So there's a bunch more. We're going to keep doing that. Please, either call in or send an email, ask questions, and then decide for yourselves.
What about taxes?
I'm sorry?
What about taxes?
What kind of taxes?
Reno taxes. Property.
Well, that's what I'm saying, that we expect that we will be able to get this and get the assessor to agree, because we don't pay, the association does not pay property tax on common area. So if this deal goes through, we expect to bring that land in as common area. We're just going to lease that back to them. So on that basis, we're assuming that we're not going to have to pay property taxes. But that is up to the Washoe County assessor, and as I pointed out, we provided in the deal that if they come back and say, no, you have to pay property taxes, we will add that amount every year to the lease payment.
The water rights. Now, you said you have an agreement with the developer that we can buy the water rights. Is that pretty well in concrete?
Yeah, yeah. I mean, it's in concrete as much as any of this is. But the fact is, yes, he has agreed, well, it's kind of complicated. We're actually buying the water rights from the golf club because he gave those or sold them or however they did their transaction to the country club when he turned over the country club. But he has underlying reverter rights. So we're going to get the water rights from the country club and we're going to get the reverter rights from him so that he will not have the ability to have the land revert to him if it stops being a golf course.
Was an appraisal done on the property and the water rights? And was it done by a professional appraiser?
Not yet. That's part of the due diligence stuff. We're looking at what we need to do in that regard. I mean, it's the same thing. When you buy a house, you don't hire your inspector, get your appraiser before you have a signed contract.
Not necessarily.
Yeah.
That most people don't.
How do I know 2.75 million is a good value?
Well,
If I never went out and got an appraisal of what the...
okay, but I mean, that's what I'm saying. That, give us time to finish the due diligence because we're looking at, but to try to give you a feel for it, we did, what do appraisers do? They look at comparables. We gave you some I'm not saying that's a good appraisal. I'm just saying
Well, they don't
we're in the
necessarily
due
always
diligence.
look at comparables.
Well, the point is, there's a couple things here that complicates that question. It's actually an interesting question because the question is, is if we get an appraisal, what is it that we're having them appraise it for? Because you can say, oh, have it appraised as a golf course. Okay. I mean, that's a useful piece of information. We're not buying it as a golf
To the
course.
highest and
Highest
best
and
use.
best use.
Well, but it's not free to the highest and best use except to the developer.
That determines the value of
Well,
land.
Yes and no. Because if a third party comes in right now, okay, the golf course has the right to sell that to another golf course operator right now. Now, do you think if it has underlying reverter rights, are they going to pay the same they would pay for getting something free and clear? No. Okay. I think the more interesting, I mean, to me, the other part of this, because we have looked at comparisons and stuff, but from my perspective, I'll say we're not buying this as a golf course. We're not buying this to get a golf course to have a golf course. We're buying it to prevent it from being developed. So the question then is, okay, what's it worth to a builder? Well, it's going to be worth more to the developer if he wants to develop it because he gets it for free, okay? It's worth, if you look at what we sold the few lots for, we just sold 39, well, earlier last year, we sold 39 lots from the View to a builder. So I kind of look at that. What's the going rate? That deal closed earlier this year, so it's reasonably current. What's the going rate for land to be used for residential housing with kind of the wholesale rate? Well, if you use that for this acreage, you get a number that's just north of $25 million. Okay, but that land could also be used for commercial uses. So now you have a totally different type of appraisal.
It's
So-
zoned.
Right now, it's zoned for pretty much, as what I've been told, it's zoned for pretty much anything, because the developer, I assume, okay.
No, it's zoned for recreational.
Well, no, that's right, but I mean, if it goes back to him, he's got all kinds of rights that nobody else has for that land.
Okay, I do have a
Well,
question.
okay, second.
Okay, just a quick one. Are there going to be any soils testing done by a soils engineer?
I don't know the answer to that yet. We're going to consult with our engineer, because a lot of that stuff has already been done, so the question is, do we need to redo it? We're going to try, that's part of the due diligence.
If the golf course went away and we owned it, have you done any assessment or considered what it would cost to maintain, to mow the lawn if it stayed green?
I've actually, one of the answers we just posted on the website yesterday afternoon tries to answer that. And we've certainly thought about that but it's a hard question to answer for this reason. Whatever answer we make is very speculative, okay? Because to answer that question with any kind of accuracy, you have to say, first of all, when does it revert to us? Does it happen in a couple years? Does it happen in 20 years? Okay, what's the cost of all the landscaping, labor, and materials and stuff at that point in the future? How have homeowners voted what to do with that land? Is it going to be a golf course, or is it going to be green space, which is a lot cheaper to maintain? Okay, I mean, there's just a whole cascade of questions that come up that basically, I would say, pick whatever number you think, because it's really hard to choose a scenario in order to answer that question, because there really are a lot of questions and a lot of assumptions you have to make. You know, are we going to landscape it more? If it came back and we decided to just keep it as green space, we're going to landscape it, or just leave it the way it is? Let the grass grow taller, stuff. I mean, there's all kinds of stuff. So I don't really know how to answer that question with anything other than pure speculation.
Is this a new ballot that's coming out, or are you extending the original?
No, this is a new ballot. Okay, we're anticipating that this will go out and voting will start around the beginning of April. And let me answer a question that's kind of implied by that, because it has come up in a lot of meetings, and that is, what's the relationship between this vote that we have going right now for changing CC&Rs and this deal? And do we need the one in order to do the other? And it keeps coming up, so I guess I haven't answered it very well before, so I'll try to answer it again. Okay. If the CC&R, the CC&R changes specifically clarify our ability to buy and annex land. Okay. If those changes pass, they will be permanent changes to the CCRs. They will apply to this deal and any other deal in the future. Okay. So in that sense, yeah, if they pass, then not a problem. Okay. If they don't pass, what happens? Well, if they, and this is based on, I've had this discussion, I've had a couple discussions with our attorney, and this is my understanding. Okay. If the CC&R changes don't pass, okay, then what's going to happen is you're still going to vote on this. We have an agreement with the Attorney General's office that we're going to let you vote on that. We're going to still vote on this. What would happen if the CC&R changes don't pass is that as part of that ballot, what you're going to be voting on is telling us either yes or no, we want you to do this deal. And if yes wins, it's also an authorization to do just this deal. So there won't be any permanent changes to the CC&Rs or anything else, but what you'll be voting on is basically that, you know, you're going to say, we want you to do the deal, and we authorize you to do this one specific deal and to do whatever you need to do.
But the reason for this vote having to be made is because the golf course is initially failing now. That's why SOA has to subsidize it.
No, that's not the reason for this vote. The reason for this vote is that it's a big commitment, and the current board feels that this is something that should be put to a homeowner vote. I mean, we're going to be, you know, making a commitment for a long period of time. It has pros and cons. The cons primarily is it's going to cost $2.75 million. The pros is we secure the use of that land to make sure that we control it. So that's why we're voting on this particular deal.
Isn't the Attorney General making you vote?
No, we had told her that that was our plan originally. She asked that question.
If it does not go through, does the Attorney General come back to you then?
Well, what I assume will happen is, I mean, you know, it's kind of a weird situation because the complaint is toward the contract that was put in place with by the previous board and the developer board, and that contract goes away as part of this agreement. Okay, and the Attorney General's already said, well, if that passes and the homeowners approve it, then nothing's going to happen to it. If it doesn't pass, basically from this board's point of view, we call the Deputy Attorney General, we say, hey, it didn't pass, and then what she does at that point or who she goes after is totally up to her.
Well, then $15 extra assessment would then come back to the residents of Sierra Canyon?
Well, no, because,
Because there was no vote on that.
well, I know, but there's no, our CCNR did not require a vote on that. Okay?
Yeah, the state law does.
No, it doesn't. No, it doesn't.
Well, why did the Attorney General get involved?
Okay, because the question there is whether the developer board, whether the developer particularly did some self-dealing in doing this deal, whether he did it for his benefit, i.e. to get out from under the cost of the golf course, which is a conflict of interest or fiduciary, whatever the legal issue is. Okay, it was not because the homeowners didn't vote. Our current rules, and that's why if you look at the CCNR changes, for example, we put in some limits that say anything over a $500,000 acquisition, for example, must have a homeowner vote. If that doesn't pass, $500,000 is unlimited. Okay, there is nothing in our current rules that would require a vote on this deal or the
I'm
previous
just
deal.
confused because state law is superior to CCNRs.
Well,
And it requires for homeowners associations to vote whether or not they're going to receive additional assessment.
no, it requires them, that's partly correct. Okay, first of all, that previous deal did not require a special assessment, so it wouldn't have had a vote. What the Nevada law, there's only like maybe half a dozen things that Nevada law says you have to have a homeowner's vote. And you're right about special assessments if the special assessment amount is greater than a 25% increase of the general assessment amount for the previous year. So, you know, a board could impose a special assessment of a 24% increase. Doesn't require a vote. 25% requires a vote. That's what state law says, as I understand it.
Yes, on this lease agreement, when you say
Now, which lease agreement? You're talking about the original one?
current, no, the new lease agreement.
Okay, it's not a lease. I mean, that's just a purchase.
Well, okay, whatever the agreement is
Okay,
that we're gonna vote on in April,
right.
could you define for me homeowners vote? Are we talking 2,500 homeowners and we need a simple majority? Or are we talking this thing that goes back to a quorum and?
Okay.
it's
What
a
are our
very
current-
small
okay.
number.
That question's come up at every meeting, and I think I've answered it the same way at every meeting. Here's what I think will happen, and the reason I say I think is because until we get to, and I've said before that obviously this is gonna be a legal issue, we're gonna pin this down, but I don't wanna pay an attorney to pin this down if we don't even have an agreement yet. So that's why there's a little bit of wiggle room here, okay? As I read things, and based on my more casual discussions, what I anticipate, okay, our current CCNRs, the way they're written right now, they give homeowners rights to do certain things independent of the board, okay, including calling a meeting and including, transacting business, okay. Now, what Nevada law says about that, which is what we've adopted in our CCNRs, when I say we, that's what the developer put in the CCNRs when they were first written, okay, is that Nevada law requires for business that homeowners can transact, regular business. There's a few special exceptions, like there's special voting for electing a board, special requirement for changing CCNRs. But for all the rest of the business, it says the question would be decided by a simple majority as long as at least a quorum of homeowners vote. So the answer is, it will be decided, and I assume that's what's going to apply here. So if that's the case, it will be decided by, in order to pass this or approve this, you'll need 50% plus one of all the ballots that are cast. But you have to have at least a quorum. Okay, and this is really important to us because, and the reason I think the state set that quorum, and the quorum is some people think it's too low, it's 20% of homeowners. Okay, that's a quorum. Okay, but if you look at all of our recent votes, the last election, we had less than 1,000 homeowners voting. So 1,478 did not. Okay, for the Moana ballot, which was overwhelmingly approved. 96, I think, percent of all the votes were yes. We made the threshold by 33 votes. Okay, out of 12, almost 1,300 votes that were cast. Okay, so the truth is, when you're talking about homeowner business, even with the 20% quorum, okay, it only takes a handful of people to block anything, because you can count. We've had in every election we've had between 40 and 60% of homeowners not voting.
But you keep extending the time frame, should you get more people in?
Well, hopefully we'll get it, like, why did we extend the time frame? We only
Because
had,
you didn't get an answer that you wanted. so
no, we don't know what the
extended
answer is. We have not opened the ballot yet.
True,
Okay?
but you know, if you have to have a certain number, if you have to have 1,100, you only have 90,
Well,
it
that's
tells
right.
you you're 200 short.
No, but it also tells us, we don't know whether those people would be for it or against it. So we don't really know what homeowners want. All we know is not enough people voting.
So you didn't have a chance to get it one way or the other, so you extended the
No,
time.
no, I mean, you can think of it however you want. Okay, but what I'm telling you is, there weren't enough votes cast to either pass it or to positively reject it. Okay, you can't say that 50% plus one of the homeowners were against it, if, no matter what the voting is, so.
What's the quorum on that?
A quorum, yes, but that particular, changing a CCNR requires, the quorum doesn't work for that. It doesn't apply. It's 50%, you gotta have 50% plus one or 51, I gotta go back and read the thing, but it's of all possible votes. So everybody, so you gotta count it that way. That's one of CCNR changes, board elections, and ratifying the budget and sustaining legal action that the association initiates. Those are 4 things that require a homeowner vote by state law. Okay.
Strictly on a personal basis, I'd like to congratulate the board for all the work that you've obviously done, trying to nail together an arrangement that will satisfy all the parties. My question is, will there be significant changes made or required in the CCNRs in order to accommodate this?
Well, as I said earlier, if the current CCNR changes pass, then that will automatically accommodate it. If they don't, the ballot that you vote on will basically be authorization to implement just this one deal. So it won't require a permanent change in the CCNRs, but you do have to authorize us to do this. And if you don't authorize us to do it, which basically is if you vote no, then it's not going to happen. Okay. The other thing, though, just kind of, and I know there was a lot of rumors and accusations and stuff that the whole point of the CCNR vote was to try to slide this through in some way. Okay, and hopefully you understand now what's going to happen with the votes. The purpose for the CCNR thing is that there's also other business that we've talked about in terms of being able to enforce the CCNRs down in Town Square. We've now been approached by the owner of the second empty lot to say that he's interested in talking to us about selling that lot. But, so now there are 2 empty lots, either one of them would give us the voting control to enforce, making sure the lights are maintained and it's not a parking lot for cars for sale and, the landscaping's all done. Any additional land we can buy down there will give us enough voting clout to do that. But until we get the CCNR change, we're reluctant. I mean, we've had legal opinions that tell us we can't. But we also have some that say, well, I mean, obviously in the Attorney General's complaint, well, she actually only talks about leasing. So I can't say that that affects that. But we don't want to get into a situation where we do something like that and find out we shouldn't have. So that's why we're trying to
A lot
clarify.
in the town center would be a Somerset's investment. It wouldn't be a Sierra Canyon's.
That's right. That's right. But to change the CCNRs requires
Yes, yeah,
Sierra Canyon
I
voters.
just wanted to,
Yes.
you brought that up.
No, that's right. Well, let me back off and say that slightly differently. I suppose, to be perfectly honest, it could depend on what happens with it, in the sense that, and this is something that you'll see in some work the strategic planning committee's going to do, and we've all, I've had a few informal discussions stuff. I don't think we should necessarily be totally separate communities unless you guys want to be. So there's nothing that says if we were to build another amenity, whatever it is, that it couldn't be made available to you guys if you wanted to be part of it. So in that sense, maybe if we
If you
build
took a
something else.
vote out here, we would like to separate.
Well, that's, I've heard all sides of that issue. So, and we'll see, but the point is, yeah, if it's used for expanding amenities just for the residents outside of Sierra Canyon, it'll be paid for just by the residents outside of Sierra Canyon.
I have a question with regard to the developer giving us his converter rights. What's in it for him? Why is he doing that?
I can't answer why is he doing it. What's in it for him is, as far as I can tell, nothing.
He's giving up something.
He is giving up something. We refused to make that contingent on anything. We're not paying him anything. We're not giving him anything. I can't tell you whether the golf course is. As far as I know, they're not. But the SOA is not.
He's getting rid of the risk of being taken to court by the Attorney General.
Well, that's a tricky one because, and this is something that concerns me, that deal was done by a legally put in place board, even though the developer controlled it. Nevada law is very clear that it requires the association to indemnify any board member, unless there's like outright fraud or something like that. So I don't think he's really too concerned about that, because if they go after him and he has to pay something, his attorney, when that meeting came up with Las Vegas, we've already received the demand letter that says we expect you to pay all our expenses. So I'm not sure if that's going to apply or not, but.
Well, I want to thank you, Tony, for giving such a clear presentation, kind of leading us through the whole picture.
Oh, well, I appreciate your patience. I know it's kind of a long presentation, but it's not a straightforward deal.
Will the equity members of the golf course vote on this agreement before it's put to the homeowners, so that our vote, if they are gonna disapprove it, isn't just wasted?
I'm not really sure, and that's because we don't control the timing of their vote. Our timing is driven by being able to get through all the due diligence that we think we need to do. And I'm hoping it'll take less time than that to get the agreement in place. So once we get the agreement, they're free to vote. We may or may not be ready to vote at that point, depending on what we still think we need to do for due diligence. So I don't know the answer to that question. I could just say casually, the last time that topic came up in one of our discussions, I think they were planning on voting a little bit before we vote, but I don't know if that's going to happen or not. Ed, I saw your hand.
Yeah, with respect to the current documents that convey title, it's a determinable fee title, which means that the club cannot give us a fee simple title.
That's because of the reverter, I assume.
Reverter,
Yeah,
right.
but we'll get the reverter.
Okay, so how's that going to happen? Is it all going to be done simultaneously in one document, or will the developer do that first, or at least they have a document available that will do it?
Well, I assume it'll all happen simultaneously as at a closing. Now, we don't have all the answers to that yet, because it's actually even more complicated than just that. That's the land, which you would want to buy fee simple, but it has a reverter. The water rights tend to get transferred in a different way. Okay, those aren't done by the same kind of process. The infrastructure, the pipeline down to the Truckee River and stuff, that's a whole different ball of wax too. All I can say at this point is we're aware of all those things. Our intent is to do the transfers in whatever form is most advantageous to the association. Okay, there are also some other things. There's a water sharing agreement that's tied to the infrastructure that has to be changed, so that contract's got to be rewritten. So there's a bunch of things like that, but we're aware of that. We're going to do whatever's in the best interest of the association.
There's also a reverter right with respect
Right,
to the water
Canyon
rights we have for Canyon 9.
Yes.
Tied to our debt to SDC.
We are certainly gonna put those in there. Quite frankly, we'll see if we can. But there are other ways. We've got a plan B for those. Those we can deal with. Any other questions? Dan?
You said you were gonna make available a copy of the draft contract, well in advance of the vote.
No, I said before we vote. Yeah. We'll put it up as soon as it gets signed. I mean, you know, we're still trying to draft it right now. And
Well, I mean, is that like the day before? I assume when I say well
I
in
don't know,
advance.
but that's why, you know, Dan, we're gonna put it up. Can you tell me how long the lawyers are gonna take to agree to this? I don't know. What we're gonna do, as soon as we get the agreement signed, we will make it available. The voting period will probably be at least 30 days, probably more likely 60 days. So even if you get it, you know, if we start the vote right after that agreement, there'll be plenty of time to review. That's all I can say right now, because we don't know when it's gonna be
My
done.
question is, will drafts of the deeds for the land and the water rights be available as well?
That's a good question. I don't know the answer to that one. I don't know when that gets done.
I mean, I can just see Blake Smith pulling a fast one.
Well,
So,
but,
that's
you
why
know,
I think it's
we've
very
got-
important for these things to be examined.
Well, and they will be. I mean, that's why we've got lawyers, that's why we're looking at this stuff. That's why we're gonna make stuff available to homeowners when it's available. So, yeah, I mean, I share your concern. Nobody here wants to see the developer pull a fast one, and we're doing everything we can to make sure that doesn't happen. And the deal, we will not, you know, finalize the deal and go through the closing, and we certainly won't turn over any money until all that's done to our satisfaction.
One more question on the water. What about the structure getting it from the river up there? Who owns the land that those pipes are on? Does the developer still own those?
Now, I believe that's an easement, but I believe, but again, that's the kind of stuff we're looking at during due diligence. You know, we just have started that process now as the holidays ended. But that's the kind of stuff we need to go into.
Because we've got some water rights, we have to get it up here.
Right. I assume it's just like, you know, we've got gas pipelines and various kinds of pipelines and electric and phone and cable running all through Somerset, and that's done by an easement. So I assume that, because I think some of that land may be state land or something where that pipeline is. So I assume that'll be done, but that's the kind of stuff we're looking at. Anything else? Thank you all for being here.